Good morning, everyone. Welcome to the 9th webinar in the TU Dublin Hothouse webinar series. Dr. Andrew Marsh, who is our Senior Licensing Executive, will discuss how IP is managed in TU Dublin and provide examples of how to protect your idea, product or service. Welcome, Andrew, and thank you for being here again today.
Thanks, Danielle, and thanks everyone for tuning in. So as Danielle said, this is sort of an overview on intellectual property, and in particular with some TU Dublin examples and how it's the processes for managing intellectual property within TU Dublin. I'm just going to give a quick overview on our offices, and then talk broadly about what is intellectual property, and then maybe get a bit more specific about how we do things in TU Dublin. So as Danielle said, I'm the Senior Licensing Executive within TU Dublin Hothouse. So what's the role of Hothouse? We're part of the Knowledge Transfer Office within TU Dublin, and it's our role to commercialise and try and exploit intellectual property that's generated by researchers. We also have a role in entrepreneurship training through our New Frontiers program and our incubator. You can see the team here. It's led by Paul Maguire, who's the head of innovation and enterprise. There's 3 licensing executives, Danielle, who started the call there, who's our marketing manager, and Maria, our administrator, and Bernadette, our incubator manager, and Shauna, who looks after business development, bringing in new companies for our researchers to work with. So sort of a broad and experienced team. We are the lead in the DRIC consortium. So the DRIC consortium is a group of universities and institutes of technology in the Dublin region. So there's ourselves, and there's Dublin Institute for Advanced Studies, National College of Ireland, and IADT. And the role of Hothouse is to help all these other organisations in the area of knowledge transfer. I'm very proud of the impact of the office over the years. For example, our client companies have created 1,700 high-tech jobs, and we've had 41 spin-outs from the TU Dublin research. We'll talk a little bit more about the spin-outs later. We have sort of 4 broad groups of people that we help. There's industry, who we try to link in with the researchers. For researchers, we look for industrial partners and help them commercialize research. Students, we'll help them develop out ideas. And startups, we have a range of support for startups and entrepreneurs as well. Specifically for researchers like yourself, I think probably most of the people on the call today are researchers. We can assist you with commercializing your research through either licensing or spinouts, and we will help you to protect the IP in your research. So that's pretty much what the topic of today's conversation is about, mainly about the protecting IP, but also a little bit about the commercialization and the licensing. This is just a quick broad overview of the office before I jump into the main part of the talk. So what is intellectual property? I want to distinguish between intellectual property rights and intellectual property. So intellectual property is pretty much anything, any product of the human mind. So an invention, a brand, a piece of art, a book. These are all examples of intellectual property. And each type of intellectual property has an IP right. So for inventions, we have patents. For brands, we have trademarks. And for literature, we have copyrights. And the reason we have the IP rights is that they allow the creator of the intellectual property to capture the value in that intellectual property. If you think about real property, for example, my car, I get to enjoy the full value of my car because it's a physical object that I lock in my driveway every day and nobody else gets to use it. That's not the same if I write a book. If I write a book, anybody can copy that book and sell it, and without intellectual property rights, I, as the creator, would be disenfranchised. So when we think about the IP rights, they're commercial tools that help the creators of intellectual property realize the value of that intellectual property. And so that's what we do in Hothouse in the office, that the researchers are creating great intellectual properties. I mean, we work in a university most of the outputs are intellectual. And it's Hothouse's role to put in place the commercial tools where appropriate to allow the university and the researchers and all our stakeholders to enjoy the benefits of that intellectual property. So probably the most well-known and most discussed example of an intellectual property right is a patent. So a patent is something that is granted for an invention, and it gives the inventor the exclusive right to stop other people from making, using, or selling the invention. So it's worth unpicking some of the terms in that. First of all, a patent does not give the inventor the right to do anything. Just because you have a patent for an invention doesn't mean you can actually make, sell, or use that invention. There may be many other reasons why you cannot. But it does allow you to stop other people from implementing your invention. And what do we mean by an invention? Not everything can be patented. So an invention needs to be something that's new, and it needs to be inventive. So it needs to be not only new, but it needs to be sufficiently different from stuff that's been invented before that it's worthy in some way of protection. And then it needs to be some sort of device or process. It has to have some sort of physical effect. And for example, we would not be allowed to patent a method of walking down the street, right? So this is not going to be patentable. This is just something that somebody would do. Or a better example, like business processes are generally not patentable. So they might be new or an inventive way of doing business, but it doesn't really have a technical effect, so it's not going to be patentable. And what is and isn't patentable, is constantly changing as courts and laws are changed. But roughly, something that is technical and physical, new and inventive, should be patentable. And in my view, it's somewhat of an extraordinary right. So if you think about a situation where two people work diligently for a year to solve a problem, and Mary solves the problem on January 1st, and Bill solves the problem on January 2nd, and Mary files a patent for her solution on January 1st. And it happens to be the case that Mary and Bill both come up with the same solution. They both come up with the same invention. Then Mary's patent will stop Bill from actually utilizing his invention. So he did the right thing. He worked hard. He solved a very difficult problem, but because of the law and the fact that Mary beat him to it by one day, he's now not allowed to enjoy the benefits of the work that he did. So it's not really a moral right. It's just more of an incentive. So the purpose behind the patent is that it incentivizes companies and people to invest in inventions and solving difficult problems. Just give you a quick example of that. Well-known drug Lipitor, which is a cholesterol-reducing drug, was invented and patented by Pfizer, and Pfizer's cumulative revenues on this drug were $115 billion. So they managed to get a huge amount of value from this. But you can see I have a graph up here on the screen of, their revenues by year, and you can see sometime after 2011, the revenues fell off a cliff, and that's the point at which the patents expired. So at that point, other drug manufacturers were able to come in with generic versions of the drug, and it was now impossible for Pfizer to extract the same amount of value that they've been doing for the previous 15 to 20 years. Now the cost to bring a drug to market is well over $2 billion. So Pfizer would argue that without this opportunity to really extract a huge amount of value when a drug is successful, they would not be in a position to continue to invest in the R&D in drugs, many of which would fail at the final hurdle. And hence we wouldn't get all these wonderful drugs that help save people's lives. So that's the deal with patents. It's a deal between inventors and society. Society says, if you work hard and you invent and tell us about your invention, we'll give you about 20 years of a legal monopoly to try and exploit that invention and at that which stage it goes into the general good and anybody can use it. Okay, just an example from TU Dublin. So there was a group of product design students who came up with an invention. It's a method of determining if there are parasites in cattle, and they have set up a company and are doing very, very well commercializing this product. But in their particular case, for their particular technology, it's crucial that they have a patent. And a patent was filed with support of Hothouse for this particular project. And the reason is that without a patent, their final product would be relatively easy to copy and to reverse engineer. And so without that patent and that guarantee of exclusivity, they're going to find it very, very difficult to get investors to put the money that's required into bringing this product to market. So this is a concrete example of where Hothouse would put in place this commercial tool, this patent, to help support the outputs of research. Okay, so that's a quick view of patents. A second type of IP right that most people are familiar with is copyright. Copyright applies to creative works like pieces of art, theatre performances, and in fact computer software. You might not think that computer software is particularly creative. I mean, it doesn't address the yearnings in people's souls or anything like that, but it is a creative expression, so it is protected under copyright. And if you have copyright in a work, you as the creator have the exclusive right to do lots of different things, such as performing the work, creating derivative works, distributing, renting, all sorts of things. So it gives you very, very powerful restrictions over what other people can do. And note that it only covers the actual expression, not the ideas that are beneath the expression. So within software, as an example, let's take Microsoft Excel, a product we're all very familiar with, I'm sure. Copyright law stops me from pirating, putting copies of Microsoft Excel up online, reverse to taking the source code, making changes, taking out the Microsoft logo. I can't do any of these things because of copyright law. It does not stop me, however, from creating a product that looks very like Microsoft Excel, making a spreadsheet application with text boxes that refer to each other and data types and so on. So the ideas that underlie it are not protected by copyright, just the actual expression, just the code itself. And this is a very, very useful tool for commercialization of university research. So I have an example from TU Dublin Research. So there was a group of researchers from the audio research group that spun out a piece of software that allowed musicians to separate out different instruments from an audio track. So you might be listening to an audio track that would have piano, vocals, and guitar, and their software would allow you to isolate either the piano, the guitar, or the voice, whatever it might be. And they spun this out to a very successful company that was later acquired by Fender, the famous guitar manufacturer. This was a bit unusual in that there was also a patent associated with their method of this sound source separation. But even without that, they would have been able to protect the product itself through copyright in software. So the next type of IP right I'm going to talk about are trademarks. We're all very familiar with trademarks, like the Coca-Cola logo, the Google logo, whatever it might be. So a trademark is some sort of sign, symbol, or word that identifies products or services. It doesn't necessarily have to be registered, but it's easier to enforce if it does, and it's probably the most valuable of all IP right. It can last forever. I mean, think about the value of the Coca-Cola brand or the value of the Brennan's bread brand. These are there's huge value in the trademark itself. And again, the actual value is the brand. So this is what everybody thinks and feels about a product, and it's the fact that it makes them more likely to purchase that particular product. And companies invest a huge amount of money in their marketing to try and increase the value in the brand and to make us think, warm, fuzzy feelings when we think about their product. But without trademarks, without this legal right, it would be very, very difficult for the companies to exploit the value in that, because other companies could copy their products and pretend to be selling Coca-Cola branded products, or imitation Brennan's bread, whatever it might be. You might think this is not particularly relevant for university research, but there's a very famous example in the University of Florida. So some researchers in the University of Florida came up with this product called Gatorade. So it was a recovery drink for their people on their athletics programs. It's sort of sugary water with lots of electrolytes and things in it. And this product was licensed out to be commercialized, including the initial formulation of the product and the trademark. And the real value is in fact in the trademark. I mean, the formulation has changed multiple times. Gatorade has multiple other products, but the brand is now hugely valuable. And the University of Florida, when I last looked at this, had received nearly $300 million in royalties. Okay, so the last type of IP right I'm going to talk about is sort of secret know-how. And this is probably the most common thing that we deal with in Hothouse. And so know-how is anything that's useful. It's technical data, formula, standards, whatever it might be, that is kept secret from other people. And hence it has value in the fact that it's been kept secret. And to keep it secret, you need to implement practical and legal measures. So you need to have confidentiality agreements and things to keep the information legally secret. And then, we have to take practical measures. We can't leave it lying around on the bus or in Starbucks or wherever it might be. And an example from TU Dublin, recent spin out of ours, Oppo Plan. There was a lot of money spent through a grant from Enterprise Ireland to develop a cloud-based software product. And what this product does is it automatically creates home designs and optimizes home designs. And the real secret sauce here is there's an algorithm that takes a architect's brief and information and creates this home design. And that the IP strategy here is to protect that through secret know-how, because all the calculations are done in the cloud, so we don't ever need to expose exactly how that algorithm works. So it's all protected as secret know-how, and which is probably in this case much better than, for example, filing for a patent where we would have to disclose how it's done. Sorry, there's a car alarm going off outside there. My apologies if you can hear that. I'm not sure if that's been picked up by my mic. Okay, so that's sort of a general overview on IP. If you have any questions, I think just pop them in the chat and maybe I'll address them at the end, because it's difficult for me to see the questions here as I'm going along. So I want to talk a little bit about IP in TU Dublin, and in particular the TU Dublin IP policy. So as I said at the start, I mean, IP and IP protection is important for universities because of the nature of the work that we do. We are, the research that we do, it's all focused around producing intellectual outputs. So we have a policy, and we have had a policy for a number of years across different policies across the different campuses, and now a unified policy across all three campuses. And why do we have an IP policy? So the first thing is we want to make sure that any IP that arises from research is identified, protected, and commercialized. And that's the role of the Knowledge Transfer Office to do this. And why are we doing that? Because for example, we want to promote collaboration with business and enterprise and non-profits and community organizations in the region. And the fruits of that collaboration are going to be intellectual outputs, and our collaborators want to be sure that we have good processes in place for managing those intellectual outputs. And we're looking to translate the outcomes out to society. So the good research that's done to drive impact from that. The intellectual property also deals with entrepreneurship and how TU Dublin supports entrepreneurship. And finally, we want to be able to deliver tangible economic output and a robust pipeline of high potential startup enterprises. So just briefly want to discuss one aspect of this, and that's the entrepreneurship and the business supports. So we started talking about intellectual property and intellectual property policy, and then embedded in that, there's stuff about entrepreneurship and business supports. And it's not necessarily obvious that those two things are completely linked. But I guess the overall structure from a state point of view here is that the state believes that universities like TU Dublin are going to be and are a fantastic engine of good ideas and high technology businesses and high intellectual output businesses. They're going to help drive the economy. So the next Googles and Pfizers of the world are going to come from university research. So they want to see the processes in place whereby intellectual property is captured, and then where opportunities exist to support entrepreneurs to create these types of companies, that the structures are there to do that. And that's what our IP policy hopes to do. So who's involved in this IP policy? So there's the Knowledge Transfer Office, which is Hothouse, and there's the link in Blanchardstown and Synergy in Tala. So we all work very, very closely together on knowledge transfer, and have done for 5 years, predating even the creation of the Technological University through DRIC. There's an IP committee that oversees our licenses and spinouts in particular. And the crucial people involved in the IP policy and implementation of it are the researchers and the principal investigators and the students who are creating the intellectual property. We have other stakeholders are the groups that are taking on this intellectual property, so business, community groups, government, startups, entrepreneurs. And then key stakeholders are funding agencies who are providing us the substantial amounts of the funding that we use for creating this intellectual property. So the IRC, EI, SFI, and Horizon through the EU. I just want to get some of the details then of the intellectual property policy. It's available on the TU Dublin Hothouse website if you want to look at it in more detail. We start off in the IP policy and we talk about the importance of identification of IP. So what we're looking for from researchers and from staff is that they will tell us in the KTO, whether it's in Blanchardstown, Tala, or in City Campus, about something that they've created that they think might be useful, might be commercializable, might be exploitable by somebody. And they do this before they publish. So our activity should not interfere with your publication, but once you've published, it can often be too late for us to do anything with the IP. And this is particularly important when the research is externally funded. We often have obligations to the funders, and we need to capture the intellectual outputs of the research to allow us to fulfill those obligations. So, there's a judgment to be made. We can't know about every single intellectual output that's created by every staff member, and it's just obviously not practically useful or feasible. But if you do come across something in your research that you think could be useful, just give us a quick email or a call, and we can discuss it with you very quickly and see if it's worth pursuing any further. So very topical always is the ownership of IP, and the TU Dublin IP policy is a bit different to the IP policy of most of the universities in that we allow staff and students to own IP they create, unless there are certain situations that arise. And these are very, very important to consider. So the most common reason that staff and students don't own the IP that's owned by TU Dublin is that you have to assign that IP to us or a sponsor, for example, for externally funded research projects. If we get money from Science Foundation Ireland to fund a postdoctoral research position, we have to tell Science Foundation Ireland that we will own the IP created by that postdoc. It's not up for negotiation. It's not something that we can do in any other way. It's the same with EI, Horizon, or an industry sponsor. So in those such situations, staff students won't own the IP. It's owned by TU Dublin. If the IP results from work specifically requested by TU Dublin under a written contract, for example, if you are hired to create a IT timetabling system for the university, we will own that, the intellectual outputs. And I'll just skip on to the last one. IP created using TU Dublin resources. So if you have used sort of substantial TU Dublin resources, like a lot of materials, very high-end lab equipment, things like that, then TU Dublin will own the IP. And this is where I guess there's a bit of a grey area. So it's always best to come and talk to Hothouse to see if there's going to be any issues around the research, or if TU Dublin are likely to make a claim to the IP that's created. So how do we implement this policy? So the protection and commercialization of IP is managed by the Knowledge Transfer Office with assistance from creators. So we manage the patenting, the licensing, we'll set up research collaborations, we'll decide if there should be spin-outs and so on, with assistance from creators. And this is hugely important. We are not the originators of the IP, and the creators are the ones who understand it. The creators are the ones who companies want to work with. The creators are the people who the investors want to invest in. And so we need the buy-in from the creators for us to actually protect and commercialize the IP. And one of the main ways we do this is through spin-outs. So if there's TU Dublin IP that could be exploited by a brand new company, we will help set up that company. We'll take an initial stake, typically 15% equity, and there'll be a license from TU Dublin into this new company. Okay. And sort of financial benefits then to the inventors. So revenues that come in through the exploitation of IP, most of it flows back to the creators of that IP. So the revenues are the money we can get in from exploiting the IP, and we take away our costs. Typically that's patent filing. And I won't go through this table in detail here, but you can see, for example, for the first €100,000, the creators would split between them 75% of the net revenues that come in. The research group or the college would get 10%, and then TU Dublin Central would get 15%, and sort of scales down. So again, it's probably one of the more generous revenue distributions IP policies in Ireland. Right, and so I'm just going to finish up by talking briefly about some practical steps. So we started talking about what is IP, these four main types of IP that we see: the patents, copyright, trademark, know-how. And we've seen some examples of how those can be used to help support the commercialization of research. And I've just dug in a little bit into the IP policy in TU Dublin, which sets out the roles, expectations of researchers, expectations of the university and our stakeholders around IP management. And I just want to try and translate that into sort of tangible actions then that researchers can take to help with this process. And so when you're doing your research, a good exercise to do is to have a little think about what's the value of the research output. So is it got potential commercial value? Is it of general value to society, other researchers, and why is it important to you and to your team? And if you continue to focus on that value, it can make a lot of other decisions a lot easier. For example, should you come and talk to Hothouse? Well, if the research is mainly about publications and sort of helping the CVs of you and your team, then maybe it's not as important to come and talk to Hothouse. But if you think there is commercial exploitation opportunities, then definitely you want to come and talk to Hothouse. Understand the grant agreement. If your research is funded by an external grant, that money will come with a very long and boring document called the grant agreement, and nobody is expecting you to read every word of the grant agreement. Maybe they are. I don't expect you to read every word of the grant agreement, but you need to understand the main provisions of it as they apply to you in your research. So what are the expectations of you? Who's going to own the IP? What's expected around publications? Are you expected to notify project partners about publications prior to publication? And we are here to help you understand that. So if you have any questions about it, please come and talk to us, and we can make sure then that the projects are all run very smoothly and without issues. So we talked a little bit about IP ownership and who owns IP, but there are very practical steps that we need from researchers around IP ownership. And in particular, it needs to be very, very clear who is involved in creating the IP. And it's kind of up to the PI, the person managing the project, to keep a record of who's working on the project. They're the only people who can actually practically do this. And sometimes it's easy. Sometimes it's just staff members involved. Sometimes it's people who are hired under the project. But we often find situations where at the end of a project, we find out that there was an informal collaborator from another institution who were not discussed at the grant agreement stage, who were not discussed at the project plan stage. And then it's not clear who owns the IP that was created by that particular collaborator. And we end up having to sort of retrofit agreements and do a bit of firefighting. And so again, the PI will need to keep a very clear record who's working on the project and what their roles are. Something that comes up a lot in projects is the difference between background IP and foreground IP. And before every project, there is all the stuff that has been created before the project, which is called background IP. And it's IP that we're going to use in the project that exists prior to the start of the project. It can be software, it could be a patent, it could be a software platform that you're going to improve and build upon. And a lot of times going into a project, there is no background IP. You're doing something brand new, and you're not building on anything other than publicly available information. That's fine too. So at the start of each project, somebody from Hothouse will contact you just to ask you about, is there any background IP be brought into the project? Because we need to ensure that we're allowed to use it in that project. So the IP may be owned by a third party. We may have rights. Our third party may have rights to that IP. There's all sorts of issues that can arise. And it's the job of Hothouse to sort of pour through that and make sure that the IP that you want to use in the project is free and available to be used in the project. And then foreground IP is the IP that will be created in the project. Okay, so for foreground IP, what we need from the researchers is there needs to be proper documentation on the work that's done. And this is something that researchers do in the course of their normal work. So whatever it is you do in the course of your normal work, whether you keep lab notebooks or whether you have you keep your code on GitHub or whatever it is, it's fine once there's evidence of what was the work that was done and who did it. And then what we do at the end of a project is we do either an invention or software disclosure form that will capture sort of an overall snapshot of the IP that was developed in that project. So it could be the final version of a piece of software. It could be a great invention that was developed by a postdoc during a project, whatever it might be. And that acts as sort of the starting point for commercialization within TU Dublin. So this invention disclosure or software disclosure form, once we have that from you, we can sort of start the formal process of trying to commercialize that IP. Okay, a little bit on confidentiality. So, as I said, if we may have obligations to partners, or you may have ambitions to commercially exploit what your research outputs, publication can destroy that. It can stop us from filing a patent. This strategy of protecting like we did with the Oppo plan case, the strategy of protecting the idea through as confidential know-how, it will be gone obviously if it's published, and it can get us in terms with problems with the funders. If we disclose any sort of partner confidential information, we can end up with litigation. This hasn't arisen, hopefully never will, but probably much more likely it would just end up with a loss of reputation, and it can destroy a relationship with the company or partner that we've worked with over the years. So you need to be very, very careful around confidentiality. And I know it can kind of go against typical university norms. I mean, university research is supposed to be sort of free and open. And, you know, we do encourage people to publish, and all these processes shouldn't stop you from publishing. But at the same time, there are, you know, some straightforward rules that we do need to follow to make sure that we don't prematurely destroy the commercial value of IP, or, you know, irreparably damage our relationship with a partner. And the specific roles of a PI in this is to understand the confidentiality obligation. So what you can and cannot disclose. Make sure you call us to tell us before you do any disclosures, like publications. And as PI, you're sort of responsible to make sure that people in your team understand the importance of confidentiality. Okay, I'm low on time, so I'm going to skip the next one. And just my last slide is just on publication. So there's this constant conflict between commercialization and publication. As a researcher, you're probably very, very keen on publishing as much as you can, getting your research out there, making sure as many people as possible see it. And when you work with a company, or if you're trying to create a spin out or whatever, you kind of want to put a wrapper around the IP and make sure that it isn't seen and so on. So there can be conflict. But by and large, the commercialization shouldn't get away in the publication. I give two specific examples where it may. One is the EI commercialization funds. So this is a fund that's designed to create IP to form the basis of a spin-out company. In that case, the commercialization is going to take precedence. It's all about commercial output. So if the best thing is to not publish the IP, then that's what's going to happen. Or the other one is full contract research. So you can have, if a company comes in and pays sort of full consultancy costs for something, full economic cost plus an overhead, they will have an expectation that the results of that work will be theirs and kept secret. But otherwise, you know, all we ask is that you will come and talk to us before you publish, so that we can have decide if we want to file a patent or pursue some other commercial strategy before you publish. Okay, so just a quick recap. So we've talked a little bit at the start about overview of intellectual property, the different types and examples from university. The second part was about this framework for intellectual property in TU Dublin, which is the TU Dublin intellectual property policy. And then the third part, the sort of the hygiene, the how you do the day-to-day stuff that researchers need to do, just to make sure that we have the best chance of commercially exploiting IP and to be in compliance with the IP policy. So thanks very much for your time, and I will just see if there's any questions.